Good evening, everyone. Thank you for joining myself and Ben Mason this evening. You're joining us for the next in our series of webinars. For those of you who are joining us for the first time, my name's Marcus Rea. I'm a Chartered Independent Financial Advisor with Integrity 365, and I'm really pleased to welcome Ben Mason from Kinherit joining us this evening. As you're probably all aware, the subject this evening is the standard will versus reality. And will planning for the complexities of real life. I can assure you, you're in for a good thing this evening. Ben's very topical and interesting, so hopefully you'll find this interesting. And as I say, please do spread the word after the webinar when the recordings are released. But without further ado, I'd please like to introduce Ben to you all this evening, and we'll get started.
Good evening, everybody. Hope you're all well. And it's slightly cooler, isn't it, than the 2 weeks ago when it was hotter than the sun even at night time. Now, I think the plan, Marcus, originally was for me to do sort of 30-minute presentation, but you've had some really good questions sent in before the session, and I know we're going to get some more questions. So what my thinking is we're going to discuss is to do a slightly shorter presentation, open up, use me, abuse me, ask me any questions you want. If I can't answer it now, what we'll do, I can take it offline and we can get the answer to you at a later date. And if anyone needs to come to us for a discussion, we can do that as well. So let's start the presentation, Marcus. But I say, as the questions come in, let's get the questions asked. More than happy to do so. And if we then have time, we can go back to more presentation towards the end, but let's see where we get to.
Yeah, absolutely. And if we don't have time to address all of the questions this evening, please do still raise any questions. And if we can't get back to you this evening, we will come back to you in due course. But yeah, if you would like to start sharing your screen, then Ben, we'll get started.
Brilliant. Here we go. Give me the wave, Marcus. Can you see that?
I can.
Excellent. Okay, so my name's Ben Mason. I am the CEO and owner of Kinherit, one of three owners, and we've been working with Integrity now for maybe 2.5, 3 years. We're an estate planning firm, and we are a fully qualified law firm. Every single one of my advisors is STEP qualified, STEP being the sort of the highest and best regarded qualification in the sector for will writing, and we're very proud of that. The fact that every single one of our advisors is qualified, it's a big thing for us. So you don't need to know any more about me, really. If Integrity didn't trust me, I wouldn't be here. So have a look through the presentation. We cover a bit about a will, a bit about trusts. And this is a bit about real life and how that works, a bit about property ownership, power of trusts, creating the right handover, and I'll explain more about that. And if we have time, we can have a little look at the kin vault and about lasting powers of attorney. So before we start, I just want to say, if you've only got a will, that's not a problem. And having a will is essential. We really need a will. But when you've got certain levels of wealth and you consider the complications of life, it's important to understand how trusts can help with that planning with everyday occurrences. So a will gives there's no real protection there and very little flexibility. But what it does is it says where you want your estate to go, who you want dealing with affairs, and who you want to look after your children. And when we say gives absolutely, it gives both types of ownership, which is legal ownership and beneficial ownership. So sort of title and the right to use it. A trust, however, has the generational protection from the usual threats. It's very flexible. You've got the ability to sort of have considerations made by trustees, and it's going to protect against threats like divorce of your surviving spouse. So should I pass away and my wealth get left to my wife, if she was to remarry and everything's just in a will, then potentially she can lose it. Whereas if I put it all in a trust, then my half it's got that layer of protection because it doesn't belong to my wife, it belongs to the trust. That's the remarriage piece as well as the divorce. It looks about protecting around divorce, folks. It makes sure we're talking with the divorce piece around about my children getting divorced. If my little girl got divorced, I'd want to make sure that everything I passed to her and my wife passed to her was completely protected. We mentioned care fees. It's not something we say that it protects fully against. It's just there's consideration about care fees and how things are owned. The trust can help with that provision. Not necessarily always going to protect against it, but it's nice to understand how that can help. Protects against bankruptcy. This is a big one. Again, I've worked, I work awfully hard, as many of you will have done in your careers, and you don't want to see your daughter marry some rapscallion, for a cleaner version of that word, marry some rapscallion who divorces your little girl and steals all the money. Now, I'm pretty sure that if I could see you all and ask you to raise your hands and say, how many of you got a son-in-law or a daughter-in-law you don't quite like or don't quite trust, there would be a good number of hands go up. So my little girl's 5 in a couple of months, so she's a long way from that. But I haven't worked as hard as I've worked and going to carry on working for someone horrible to marry my daughter. My wife and I pass away and take that money. Same if my daughter made a decision, bad business decision, and went bankrupt. Now, she can lose her money, but I don't want to lose the estate that my wife and I have left behind. A trust can protect against that. And about generational IHT, this is a much bigger conversation that isn't for a 30-minute presentation, is it, Marcus? Generational IHT, and I always use the analogy, the Duke of Westminster inherited 10.2 billion and paid £0 in inheritance tax. How is that possible? Well, it's to do with trust work and the way in which different things are owned. And it's legal ownership and beneficial ownership, as I've already mentioned. And that trust splits them out, gives the legal ownership to the trust and the beneficial ownership to my wife and my daughter. So what is a will? Well, it says where you want your estate to go. So with a will, I might say I wanted to go to my wife, and we're both dead. I want to go to my daughter. You can state gifts. So I've got a gift going to my brother-in-law. My God, if I pass away before him, I hope I don't. Sorry, Alan, but I hope I do outlive you. But if I don't outlive him, he will get my golf clubs with a note on them saying, now I'm dead, maybe you'll beat me. So you don't have to leave a horrible gift. You can leave something nice, like a steamroller. Believe it or not, I own a steamroller, and when I pass away, that'll be left to my cricket club. When it says who do you want dealing your affairs, well, that's to do with officers, and the term officers relates to executors, guardians, trustees, and attorneys. Appointing guardians. It's so important. If you don't appoint a guardian, what happens without a will? So we'll have a little look. So if you don't appoint a guardian in a will, the rules of intestacy will determine when your estate goes, not your wishes. The court will appoint someone to manage your affairs. That can be made different, where you can retrospectively get that changed and you can have your own executors, but you don't want the courts or somebody else getting involved. You want that decision made yourself. And if you don't have guardians listed in your will, your children become a ward of the state, and the local authority will sort of take charge on what's going to happen with them. So that just a little bit of a covering there on what a will is. Now, what is a trust? Well, it offers protection. It is a barbed wire fence preventing some rapscallion jumping over and taking that money. It's got flexibility. You've got the ability to say, well, if this happens, this should happen. If they're at university still, I want this much given per month. This is the type of thing you can do in a trust. You can have flexible gifts. You can have phasing of life gifts. If they are doing this, then give them this. That's how you work with a trust. You've got all that ability to do that. It's intergenerational. And it's going to protect, as we said, against divorce, remarriage, care fees, bankruptcy, and generational IHT. So daughter marries, she inherits and divorces. What happens? Think how you would feel. How would you feel if you passed away today, or maybe your brother or sister passed away today, and their child inherited the money, and then the rapscallion boyfriend or husband ran off with the money, or half the money? Mr. Die. So if I died and my wife married someone, how would I feel if my wife remarried, and what happens? Hopefully my wife would remarry and be very happy. I imagine Marcus getting over me would be quite tough. It could be very hard. But if she did get over me about 24 hours later and she married someone that was maybe not as kind and as genuine, as honest as myself or your good self, Marcus, they might want to get involved with that estate and take that money.
Yeah.
Regarding care fees, Mr. dies, Mrs. own the house, enters care, what happens next? That's a very complicated conversation and one that would be requiring more than a 30-minute presentation. But yes, there is levels of protection that can be given by the way that property could be owned. The beneficiary goes bankrupt, trustees in bankruptcy come knocking. What happens? Again, these are real life scenarios. It's not, this isn't pie in the sky. Your children get, if you've got 3 children, one of them's getting divorced. If you and your brother have got 3 each, 2 of them are getting divorced, maybe 3. This is the level of how regularly this happens. The rate of divorce following the death of the partner is really, really high, more common than divorce, general divorce. So again, that's very, very common. Generational IHT, children inherit. What happens when they die? So if my daughter got the money without just a will, and she inherits all my money and she dies, what's going to happen? Does it go to my grandchildren? Do they know what they're doing? What's going on? Do I want my financial advisor, Marcus, helping my family have that continuity advice, making sure that money's managed properly and not just wasted? These are the things to consider with a trust. We've got a pot of money. We're going to put a fence around it. In comes the rapscallion, and the trust, or Marcus and my trustees, are there fending them off. No expense spared there, Marcus, with the graphics.
No, I like
no
it.
expense spared or given. Any questions so far, Marcus, or shall I go on a little bit more?
Not in the Q&A just yet. So yeah, please carry on for the time being.
Okay, property ownership. There are 2 types of property ownership in this country: joint tenants and tenants in common. I know why. It's largely lazy conveyancing. I don't know why so many people just go with the tick box exercise of going joint tenants. It's really not the best way for the vast majority of, okay, everyone's situation is different, but for the vast majority of people, 95% of people own their property joint tenants, and that's not the best way for them to own it. The property automatically passes across. That's not necessarily what you want. With tenants in common, the property will go as per the accordance of your will. And if it's directed to a trust, you've got that direction, the trust, that protection we've spoken about. So just owning a property joint tenants, Marcus, I'll marry you for this example. If I'm married to Marcus, I own a property joint tenants, even without being married, and I die, Marcus automatically now owns 100% of the house. Well, what if Marcus was ill, or Marcus was all the different things that can go on around that? Marcus remarries and now he loses that. There's so many considerations to be made around that. And when I say it's lazy conveyancing, I don't mean that to be inflammatory, but when you ask people, why do you own your property joint tenants? The most common answer is, well, that's what I was told to do. And when you say, were you informed of the pros and cons of how you owned it or opt to buy it? No. When I bought a house once, it said, how would you like to own your property? It said joint tenants, tenants in common, and there was a tick box to pick which one. No advice given, apart from implicit advice, which had an asterisk and said, joint tenants are the most common way of owning a property in the United Kingdom. Well, that doesn't mean it's the best way for me. That's not a consideration of my experience. And sadly, that isn't an uncommon thing that happens. It's very easy to take a joint tenant property and make it tenants in common. You should do a deed of severance, costs £195, including VAT. It takes 2 to 3 days. That's something that we do at Kinherit, and it's done. Really easy to do, to get that property owned the correct way so that it flows per your will, your trust, and your wishes. Let's examine the power of that trust again. So that's Liz and I, that's my wife's name. Our little girl's Annabelle. Did her leavers assembly today from nursery going up to what she calls big school. It was very sweet. Not a dry eye in the house. She played the big billy goat, Marcus, in Billy Goat Gruff.
Brilliant.
She had to headbutt the goat in, which was a very proud moment for a father.
I'm sure it was.
So I've passed away. We've got all these threats coming in. Steve's going to remarry my wife. Dave's going to marry my daughter and divorce her. Roy Jenkins, the old Labour MP. IHT is a taxpayer by those who distrust their family more than HMRC, was his famous quote. And then Carol from the council, or Barry from the bankruptcy court. It's just about understanding about how, with two types of ownership clearly defined, the property is now more protected. Remarriage after death is no longer the threat. Steve's not going to be able to come in and take my half of the property. There's going to be protection against Liz's half. No concern really. If Liz and I pass away, we've managed to lock up our wealth, our property, our assets, our AUM, all the money that you look after for us, Marcus, all of that, everything that you've done for us is now locked up in that trust and protected from Dave. We can reduce the impact of IHT, especially that legacy piece about making sure about generational IHT. We're not going to pay IHT 2, 3, 4 times. We're not have a 40% hit all the time. Again, we could do an hour on that, but it's about understanding that there are answers to it. And this is stuff that we can dive into with any of you watching today that want to. Marcus and the team at 365 can get you over to us.
Brilliant.
We've got a couple more questions before I go into the next bit, Marcus.
We have had a couple of questions come through. So I'll just read the first one out if I may, Ben. So there's somebody who's asked that they're separating from their wife and planning to move in with a new partner. He said that I imagine we'll get divorced later this year. What is your advice on when to change our wills? Currently, my wife and I have simple wills that goes to spouse and then our 3 adult kids. I'm 55 and my soon-to-be ex-wife is 65.
I'd have changed it the second I decided to break up with it.
There we go.
Because if you die today and if you're not yet divorced and you die today and you've got a will giving it all to her, if you die, she'll get it all. I don't know what your will says, but based on the question, I'm now reading it, it feels like that's what it's saying. So I'd change that will immediately. And then once you are divorced, depending if you marry a new partner or just move in, once the divorce is done and everything's been more settled down, we have a completely free rewrite clause in the first 5 years. Life changes, stuff happens. So we will rewrite that for free in the next 5 years once everything's a bit more settled down. Can the anonymous attendee state, does your new partner have children?
We don't have that just yet, but
yeah, if they can supply if their new partner has children, I can then elaborate on that answer because it's important for them to understand the next bit. So if they get a chance just to write, yes, they do. Okay, so perfect. So let me paint you a scenario, anonymous attendee. You and I are going to get together with me. I'm your new partner. I do apologise, I'm not quite your type, but let's just play along. I am a younger model though, so you might want that. So you and I are married. We've got children from different relationships. If I pass away, I want you, my new partner, to have the ability to live in the house we own together, benefit from it all. But essentially, I want my daughter to get everything when it's the right time. That is not possible with a will. You need to be looking at trust planning for what we call the blended family, to understand that I will die, you will have access to live in the house and access to this, that, and the other for X period of time. And then once that period of time has passed, it will go to my daughter, and you would get the same protection offered to you as well the other way around. And that's so important.
Ben, I'm just thinking, do we have much more to go on the presentation, or should we stop sharing the screen and discuss matters further? Or?
Yeah, I'll do 2 minutes in the presentation.
Okay.
So Kinherit, one of the things that every client gets is a proper handover. So that's a Kinvolt video. Marcus, you able to, rather than me talk about that, are you able to send the Kinvolt video out to attendees? Have you got a list of the attendees there?
We do have a list, yeah. So we
so
could,
I'll tell you what, we can end it now. Will you just send the Kinvolt video out to the attendees so they can look at that?
Happy to do so.
It's 90 seconds. It's something that everyone who's a client of Kinherit gets for free for life. You'll all see massive value in it. And Marcus can share that and we can get into some more questions.
Yeah.
Sharing stock.
So, I mean, just coming back to the anonymous attendee there, I'm somebody who's personally gone through a divorce, as is my new partner. We both have children from previous marriages, and very much, in the process, or in need of, should I say, a trust-based will, which I must admit I still haven't got round to finishing, but I should have done it sooner.
Naughty boy.
Yes, I am. But it just shows how easy it is to actually forget these things, and timing is crucial, because we don't know what's around the corner, and we don't know how quickly things might happen. So getting your priorities in order quickly and correctly is extremely important. We do have another question, Ben, if I can raise another one with you. What options are there to minimize inheritance tax liability if the estate includes foreign properties in a country where you may have citizenship, should I say, too?
We will need to take that offline. It'll all depend on the citizenship, it'll all depend on the type of property, how long it's owned, where it defaults to, who's going to inherit it, where they're going to inherit it, period of time owned. There's so many different things. If I answered it, I'd get it wrong, because we need this, that needs to be taken offline. And if that's the same person, I'm not sure, but I think we probably need an appointment, one of our estate planners, to properly give you 45 minutes to go through that situation, do the new marriage, do new relationship and divorce, and answer that. The answer is, depending on where it is, there are some really good ways to reduce it. Depending where it is, there often isn't much you can do. On death, it's about that, Mike Marcus. Depending on where it is, we would loop you back in to talk about what you could do.
Exactly. Yeah, very good question though. So thank you for that question. And yeah, I do suggest we look to take that offline with you, perhaps arrange an appointment with Kinherit to discuss that further, just so you can put your mind at rest and hopefully find a way forward with that. We do have a range of other questions that have come through as well. The first one, Ben, is, do you put your power of attorney in your will?
No. So your power of attorney has to be on a separate legal document, which is called a lasting power of attorney. There are two types. There's property and financial, and health and welfare. They're two separate legal documents, and they're nothing to do with your will. So yeah, that's simply an introduction to us, or someone else can come through to us, however it might be, and we can set you up with that. So quick conversation, get that sorted for you.
Okay. Outside of a will, is there any other sort of administration I should be preparing for my death to make things easier for my spouse?
Yeah. All right. Well, you were going to send the Kinvault video out now, but let's just have a quick look at it for 2 minutes. So the Kinvault is a tool that we've designed, we've built. It's ours, and Kinherit offer this for free to all users, all clients. The idea of the Kinvault is here. What we're able to do is we're able to have this administration piece, so that, again, when you pass away, all of your legal information is in one place. That could be powers of attorney that'll be needed during life, and stuff that's needed after death. So for me, let's Marcus, I'll marry you again for this example. While it might not be important for Marcus to know about my granddad's property trust while I'm alive, if I haven't sorted everything out regarding that, it can be very important for Marcus on my death. Same for electronic copies of the will, other legal documents about company setups, first marriages, deed deposit for daughter's house. What we're doing here for that person who's asked that question is we're putting in place a full legal documents and asset section, which has bank accounts, investments, insurance policies. We're allowing you here to get every single thing you want in the right place, so that you and your family, you and your life, can manage it all, and your family can manage it on your death. So, for example, when my wife and I moved house 2.5 years ago, I had every single utility. All of this is deletable and editable. You put in what you want relevant to you. My wife and I had all of our providers for our utilities in there. We're able to move house, cancel everyone, and re-establish with the new property we moved to. An hour and 25 minutes. Got all the details in there. Superb for in-life management and organisation, and superb for if I passed away today, my wife would be able to go into there and see that's the details of the electric. That's the beauty of this. It's such an easy system to use. So when we talk about administration, that would be it. You've got legal, you've got all your assets, as I say, properties, pensions, valuables, any gifts you've made, admin, the utilities, insurances you might have, car insurance, home insurance, where are the pets going, information about death, funeral wishes, all that type of stuff. That's the kin vault, and that for me is the biggest part of the administration, making sure you've got that updated. It's great for in life and great on death.
Yeah, I completely concur with that. And as you say, Ben, I think it'd be worth everybody's while if we send that link round for the attendees this evening, just so they can have a look at the video footage of that as well. Another question from Glenn this evening. I have a discretionary trust for a property I own, but what if both of the trustees die? Me and my wife are the trustees. My children and their children are the beneficiaries of that particular trust.
So one of the conversations we always have is around automatic appointment of trustees at a certain age. So it might be that, Glenn, you could go, depending who's done your trust with, whatever, again, maybe we can help you understand that. But you can go to get the trust, either edit it, which is usually very hard to do or unlikely. You might have to do a new one, where you have an appointment where your children become trustees on one of you passing away and your children attaining a certain age. So, for example, my daughter, if Liz and I were to pass away, my daughter, she would become an automatic trustee in a supervisory capacity to learn how everything works, but no voting, no power at 21. And at 25, she gets some power. I think that's really important. You can put whatever age you want there. Some people put 30. And also having a reserve professional trustee. I'm not saying an expensive professional trustee that's going to charge you the fortune, because that's not what they do. I think it's a misnomer about these professional services. But if you appoint a reserve professional trustee, they are there should the worst happen. Should you and your wife pass away and have not got your children added to it as trustees, the professional trustee can kick in. And if they're going to charge 250 quid an hour for an hour and a half's work, I've been in the industry long enough to know how much time things take, then 375 quid to sort everything out isn't a massive expense, and it'll only happen if you both passed away and your kids aren't on there. Hopefully that answers that question.
Yeah, hopefully that's answered your question, Glenn, but please do, raise further questions after the webinar if you don't raise any further in the chat box this evening. Another question, what's the difference between an enduring power of attorney and lasting powers of attorney, please, Ben?
When they were done, how they work. What I would say is, if you've not got a lasting power of attorney in place, I would probably look to do the new lasting power of attorney. There's difference about registration. What happened with a lot of the enduring powers of attorney is they're sat in a desk waiting for the person to lose capacity to then be registered. Well, that can take 12 to 16 weeks. There are other differences and other things to consider, but by and large, what I'd say the most common thing we find is an error with powers of attorney in general is that people wait to register them. My powers of attorney registered. My wife could act on my behalf, but they clearly state if I've lost capacity. My wife can't just go in to NatWest and go and withdraw £3.75. I know I got paid the other day, I have a bit more than that. But she can't go in and withdraw that straight away. Like, I've got to lose capacity. So the big thing that we find is that all older powers of attorney, whatever type they are, have got a really high percentage rate of non-registration, which is just ridiculous. It's like, why are they sat in a drawer, not registered, not able to be used? You want to have them registered, ready to use them when you need them.
Yeah, I mean, personally as well, I thought I've got lasting powers of attorney myself, both the health and and the property and financial affairs one, and I thought I was more likely to become lose capacity than I was to die. So I took off my ex-wife from those first and replaced her with my new partner, and forgot about doing the will. So yes, as you say, Ben, I need a kit. But
interestingly, there's another thing a lot of people do. I'm not telling you off, Marcus, but hey, just putting your wife as a power of attorney.
Oh, it wasn't just her.
Okay.
After the divorce, I had her removed.
But who else have you got besides your new partner?
My brothers and my
Oh,
sister.
brilliant. That's what I was about to say. Like having a couple of people there to make a decision.
Yeah.
So my power of attorney is my wife and my best man, Phil. So if I pass away, I've got two people. Phil's 6.5, 7 years younger than me. My wife's a couple of years older. So I've got, hopefully, if I was to lose capacity, one of the two of them would be good to go. And again, Marcus, it's about reviewing these documents. It's about making sure they're right and they're still current. We see a lot of wills. We'd obviously do the free will reviews, as you know. So when anyone wants their will checked out, speak to Marcus, we'll do it. The amount of wills we see that are violently out of date, it's just unbelievable. They've not got grandchildren mentioned at all.
Yeah, it's the same with financial planning, isn't it, Ben? You know, circumstances change, life changes, and as a result of that, you need to review both your financial plan and your wills and your trusts.
How many clients' pensions have you seen where they've still got their ex-wife as the default beneficiary in a pension?
Yeah, too many.
Yeah.
Or they don't even know who the beneficiary is or whether they've ever completed a beneficiary form.
We heard a horror story where there was a wife, an ex-wife was the default beneficiary on a company pension scheme. The guy passed away, hadn't married his new partner, and the ex-wife got £440,000 of the pension.
Yeah, not good. So again, another thing to review, ladies and gentlemen, please ensure your nomination of beneficiaries on your pension are up to date, because if they're not, as we've touched on earlier, if anything were to happen to you, sums of money could be going to people that you do not necessarily want them to be going to. So please do make sure with your advisor, or even if you're able to do it on your own, that those nominations are up to date. Another question that's come through, Ben, is what is a deed of variation and how does it work?
The OV's really simple but misunderstood, and also not wide enough known. So deed of variation simply is the ability to vary a will post death. So if all beneficiaries agree and none of the beneficiaries receiving the residue are under 18, and you can get probate done and the deed of variation done within 2 years of death, you can change a will. Why might this happen? The will was written in such a way that people missed out on gifts and missed out on residue, and things were done wrong, and the family want to make it right. See that quite commonly. Or there was a significant IHT bill because of the way the will was written, the way the planning was done. So the family come to us and they say, right, can we change this? And we help them work out what the right way is to do it. A couple of things must be considered. All beneficiaries must be over 18 to have a legal capacity to vary their benefit. If you're under 18, you can't do it. You must get it done within 2 years of death. And here can be the tricky part, all parties must agree. Now, for every 5 inquiries we get, we probably do 1.5, because there's inevitably people that don't agree, they don't want it, they don't speak to their brother, they think they're being hard done by, that doesn't want to do it. There might have been grandchildren left a bit of residue and they've got no capacity to do it. There's loads of different things, but by and large, these variations are fantastic when they can be done.
Okay. And what happens if someone who has passed away is in my will at my time of death?
It will go based on what your wishes are, should they not be there. It doesn't default to their will. Their will deals with their stuff while they're alive. If they've already passed away and they're in your will. Again, this is why you have reserved beneficiaries. This is why you have wills reviewed and updated. If you've got a deceased person in your will and nothing is stated to go to their share, then you're going to have executors making decisions and people making interpretations, and some might be right, some might be wrong. What I would always say is that, as an example, if I pass away, everything goes to Liz, and if Liz and I pass away, everything goes to Annabelle. Annabelle's only 4, so she hasn't got any kids. So if the car crash scenario, Liz, Annabelle, and I all go, we've got a reserve beneficiary of my brother-in-law and sister-in-law. But what we will do is we will review that as soon as Annabelle gets married and has a child. We will then, doesn't have to get married to have a child. As soon as Annabelle has a child, what we will do is we will then make her children reserve beneficiary to make sure we've always got that in there. We've got gifts going to nieces and nephews, and it's worded as such that if I think it's £20,000 or something going to one of the nieces, and if that niece is predeceased us, it will go to her daughter or her son, or whatever it might be. So these are things that have to be considered. The answer is just get your will reviewed. I know it sounds daft, and we don't make any money off a will review. We will review your will completely for free. Let us help you get peace of mind, and if we need to do something, then we'll help you.
Yeah, so one of the questions we've had, Ben, as well is what happens if you don't name executors within your will? Now, I personally would be quite concerned if you have a will that doesn't name any executors, and the kind of how
Who on earth has written that?
Well, yeah, that would be my problem. But let's assume
there will be decisions made around the appointment. Again, that's quite a complicated one, depending on how old the beneficiaries are and what's going on. But there'll be decisions made around the appointment of what might happen. You'd probably get the someone would act on behalf of the beneficiaries, or the beneficiary would act themselves and apply for the ability to have an executorship. It's mucky, it's complicated.
Yeah.
You don't want to be going there, especially if there's beneficiaries that don't get on. Oh my God, you don't want that at all.
So if there was no executors named, somebody would be found to act.
Yeah, but it's not that simple, Marcus. And I could go into it for 30 minutes. You are going to have issues, especially if there's multiple beneficiaries. Who's going to have executorship? How are they going to do it? What are they going to do? Do they get on? Do they want the same executor? Do they not want each other? That's.
And is this back to the point, maybe the advantages of appointing a third-party executor, like a professional third-party executor, to ensure that, or help manage such situations as they arise?
And you don't have to appoint them as definitively on it. Appoint them as a reserve executor. Just say, look, if obviously in this instance there were no executors, so they would therefore by default be the executor. But if let's say we're brothers, Marcus, and our mother and father left you and I as executors, let's make sure you've got a professional executor in reserve in case I can't act, or you don't want to act, or we hate each other and we need someone to referee us.
Yeah. Okay. I'm very mindful of time, Ben. I think we've got probably.
By the way, if you've ever used someone to write a will that didn't get you to put executors, never do any legal work with that person again. That is negligent.
Yeah.
Unless you told them you didn't want any executors, and I can't imagine anyone would ever say those words out loud. And even if you did, they should have helped you understand what you need to do and what your options were. That's just shocking.
Okay. Couple more questions before we probably will need to draw things to a close, because we're obviously taking up Ben's evening away from his lovely wife and daughter, and many of yours too.
Is she lovely?
Yeah. Well, I assume so. She's still married to you, so she's got to be doing something right, hasn't she, mate? So
I'm the lucky one.
Yeah, you are. Can I appoint someone else to decide how my estate would be distributed after my death, rather than having to decide myself now?
If you want everyone to fight and fall out, yeah.
Bit of a bun fight.
I would say, look, I'm going to be really honest, and I don't want to come across badly. That's a real selfish, cop out. You're putting that massive decision on someone else. I think it's really, but we're not here to upset people, but I think that's a really selfish thing to do, to say, can I get someone else to decide? If you can't decide yourself, there's a reason you can't decide. To put that on someone else is a really bad thing to do. Unless you're saying, I want to give this away to charity, unless you're saying I want to give 50% to charity and the rest to my kids, but even then, how are the children going to get it? Are grandchildren going to get it? What if your child has predeceased your grandchild? Was grandchild's predeceased then? What, all these different layers in there. Just pick it. And if you're struggling, this is the type of thing we can help with. We can help you understand decisions to make and how you come to those decisions. It is, for many people, quite an emotive, difficult subject, especially if they've got estranged children they don't speak to anymore, children from a previous relationship which they've lost connection with, stepchildren, we can help you understand all the options. We're not going to say give £45,000 to Susie. No, of course we're not. We can help you understand all the different things you can do.
Yeah. And one of the questions raised is, are people able to leave everything to charity? and how might their personal belongings, etc., be distributed in such an event?
Well, if you're leaving everything to charity, the charity will rock up at the house. If it's not worth anything, they'll skip it.
Yeah.
That's the truth. So just because you think something's got value, if you're leaving everything to charity, they're quite merciless with some of this stuff. If it's worth something, they'll sell it. If it's not, they'll skip it. They'll stick it in the bin. So if you want to leave personal belongings that you think have got sentimental value, obviously leaving them to family is a good idea. If you're going to leave everything to charity, you have got children or grandchildren, it's really, really beyond important, if that's what you want to do, as it was in with Daniel Craig, who was in the press doing it a couple of years ago, that you have an exclusion on your children. You state, I do not want my children to benefit. I want it to be the charity. Because if you just put the charity on there and you don't mention your children, you will probably find your will gets appealed, because the children will be a bit miffed they haven't inherited. Unless, of course, you've had that conversation, your children on board with it, then of course that's a different situation.
Okay. Probably last one or two questions then, Ben. How long would you say it takes for a typical will to be written and be validated for an individual?
We did one in 6 hours for a lady who was about to die. Stuck one of the lads from the office on a train. He took it to London, signed it, got it witnessed, and brought it back to the brought a copy back to the office. Like, we can do that, but amazing. That's how quick we can do it. Or what's more common is you will introduce someone, Marcus, we'll book them in, we'll do the first call with them, which is sort of like an educational fact find, going around their needs, helping them understand different things around executors and trustees and all that type of stuff. Then a nice suitability report come out explaining what we're recommending, why we're recommending it, how we're recommending it be done, guide on the different prices depending on what they do. We then have another call. Again, when I say call, it can be done on Zoom, it can be done on Teams, it can be done on the phone, whatever you want. Skype, if anyone still uses that, I don't think anyone does anymore. Then we can do that, and what we'll then do is have another second call to go through that report, helping you understand what you're going to pick. And then if you want to proceed, at that point we will send you an invoice, because everything else is free. If you don't proceed, there's no cost. So all that help and those fact finds are completely free. The report's free, only charged if you go ahead. And then what we'll do at that point is we'll then produce the documents, send them to you. What is typically the time? 13 to 15 working days.
Marvelous.
From the first call to getting out in the post, based on your diary aligning, being able to book in, have those conversations, taking the time to understand it all, then getting out in the post is 13 to 15 working days.
Brilliant. Well, I think we're shortly going to have to bring the webinar to a close. I would very much like to thank Ben for his time this evening. Hopefully everybody who's attended this evening has found that insightful. If you have any unanswered questions, please do be in touch with either myself or Ben at Kinherit. We can certainly put you in touch with Ben or a member of his team to have your will reviewed. And as Ben said, it's a free service, so please do look to make use of that. And hopefully, you know, we'll send around that video regarding the Kin Vault for you to view shortly. If there's any questions, as I say, that we haven't raised or approached today that you would like answers to, please do just reach out. But please do also look out for the recording of this webinar, which will follow in your inboxes next week. And please do look to share that with anybody who you think might stand to benefit from watching the webinar over. And I'd like to thank you all for attending as well. And please do be on the lookout for our next webinar, which will be announced in due course. And yeah, so thank you, everybody. Have a lovely evening and hope to speak to you all soon. Thank you.
Thank you. Bye-bye.